This is fun for me in one way because it's a topic that I've got a passion for, and that's kind of why we're here. This is not fun for me in one way because David managed to stack the deck. So who do I get to follow? Tim Tackix and Mary Radford. So you know it's on the downhill slide. But we're going to make it fun anyway as we go through it. And we're going to cover the panoply of VA benefits. And I hope when you leave here, you've got some information. But I also hope when you leave here that you're a little disturbed, maybe, about this. When we talk about the context of it and what you may have been avoiding in the past and you should have been following up on in the best interest of your clients. Because that's what we're focused on, is our clients. So, opening slide, Omar Bradley, 1947, is appointed as the first director of the VA as we know it today. The U.S. military had an issue, societally. They needed to return to the civilian populace some 6 million military serving members. How do you do that? Well, they said, let's find somebody that's used to directing, leading, and guiding people, and they reached out and they touched Omar Bradley. He left active duty as a 5-star general to become the first director of the VA as we know it. Did an admirable job of that. So admirably, in fact, that in 1949, we have the Forrestal Act, which is passed, that creates the first chair of the Joint Chiefs of Staff, and it creates the structure of the Joint Chiefs of Staff. So now that we've got the Joint Chiefs of Staff, we need a chairman. Who does President Truman pick? He doesn't pick any of the generals on active duty. He sees what Omar Bradley had done for the last 2 years and says, come on back to active duty. He puts the uniform back on as the first chair of the Joint Chiefs of Staff. I think that is a remarkable message into aspirationally what we would hope for the VA. This is where we're at today with the VA. Second largest cabinet agency in the government. Who knew? Who knew that the VA is in fact the second largest cabinet agency in the government? I say that because many of you are hesitant to deal with the VA, or you're hesitant to deal with veterans issues because you think, oh, it's only tangential. Oh, it only affects 10% of the clients I interact with. No, it's a big piece, and we're going to talk about how big it is. Claims. Currently, the VA tells us about 164,000 claims are pending within the VA. This was an element of some controversy in terms of the backlog associated with these claims. I will tell you as a practical matter, and I think this is borne out by some of the people in the room, that number is very suspicious, and I think the number is upwards of the 300,000s. Separately, there's some 332,000 appeals pending with the VA. So all of you attorneys, raise your hands. Who's looking for work? 332,000 appeals pending before the VA right now. The average time for an appeal is running right at about 4 years. Think about the due process implications of that. There's a lot of work out there. A lot of good work can be done by a lot of people. Here in Atlanta, or when I say Atlanta, I'm speaking for the greater state of Georgia because that's where the VA regional office is that handles all of the appeals for Georgia. They have some 36,000 appeals pending. Well, you know, if I'm looking for work, if I got a little extra capacity, that's an area that I might look towards to. And let me tell you, we'll be glad to help you with that. Always glad to bring more people in. VA had made a pledge to stem that growth by FY 2015. Well, didn't quite get there. Within Georgia, we've got some 778,000 veterans today. We add to that the 66,000 active duty military that are in the state, and then we add to that the associated family members that may be entitled to some form or fashion of veterans benefits, and you come up with a client base in the state then of some 4 million Georgians. 4 million. So think about VA. Think about VA as an area of practice or as an adjunct to what you're doing as you're dealing with the best interest of your clients, so you make sure you're not missing everything that can help them. Okay, we're going to break this up into three pieces. We're going to have the Veterans Benefits Administration, the Veterans Health Administration, and then the National Cemetery System. Those are the three component parts of the VA. VA compensation, this is money. Yeah, this matters. This is money for disability purposes because the veteran has a disability that arose as a part of military service. It's administered by the VBA, Veterans Benefits Administration, also known as the Death Star. Their purpose, they administer the money. Look at their budget. $69 billion with a B. That's a lot of money. We start with who's a veteran. Because you say, as you're having your discussion, as a part of intake, well, did the family member serve? Oh no, he wasn't in the Army. Oh no, he wasn't in the Navy. He wasn't in the Air Force. Well, who's a veteran? It's not only the traditional military that we know of, but if you can look closely on the slide, this is a U.S. Army War Department identification card for this second lieutenant. And he is a member, if you can make out the military service. Can anybody make out the military service he's associated with? Oh, okay. No, good. That'll be good. Russian Railway Service Corps. But it's a U.S. Army War Department document. Yes, 1919, 1920, the U.S. War Department created the Russian Railway Service Corps to assist in running the railroads in White Russia and Siberia as a part of the infantry brigade that the U.S. Army sent during the intervention for the White Russians during the Russian Revolution. Who here knew that? You didn't know it. But the Minnesota Railway Company raised their hand and they volunteered to run railroads in Russia. That's what it's all about. So these guys are running around. NOAA, U.S. Public Health Service, the Coast Guard, the U.S. Cutter Service, the U.S. Revenue Service, on and on and on. If you go to the CFR, it will give you a list of some 54 different agencies where veterans benefits are entitled to go to that serving person. The big one that people miss are the contract airline employees for Braniff, for Eastern, and for Pan Am that flew under contract for the U.S. Army Air Force in the Second World War. They wore airlines uniforms, but they're still entitled to military benefits. And then by statute, when you go into the CFR, there are actually 3 individuals named that assisted the U.S. Marines in operations in the South Pacific, and they're named by name. And I always have to wonder, what did these gentlemen do to have the U.S. Marine Corps go to the Congress and say, put them in by name for veterans benefits? So we scratch at first who's entitled to a determination they're a veteran, but then we have to look at their character of duty. Do they have a good discharge or not? And I know that many of us know how to ask these questions, and sometimes it leads to follow-on questions. Well, we don't know. So if you're really smart as an attorney like Danielle, you can go back to the National Archives, get a discharge certificate, the procedures to do that. But you got to make sure you got a good discharge. Bad conduct discharge, dishonorable discharge, they're going to be barred. Honorable discharge, it'll be fine. Then there's some wiggle room in the middle in terms of some of the general discharges, general under other than honorable conditions, and the VA gets to make those characterizations. They get to make those characterizations because of the Administrative Procedures Act. And of course, the individual's not incarcerated. Okay, organization for the VBA, regionally organized. Some 57 agency offices total. We only have one in Georgia. That's a picture of it down at Regional Office Atlanta. Then separately for dependency and indemnity compensation and the VA pension, regionally organized as well, but within 3 facilities only, Philly, Milwaukee, and then St. Paul. And then finally, we have the fiduciary administration that the VA conducts on behalf of those veterans that have been determined to be in need of a fiduciary. 6 hubs. The Southeast hub is run out of Columbia, South Carolina. All right, let's look at the benefits. Comp is the primary benefit we always want to go to first. We want to go to comp because it's not means tested. That's a pretty good reason to go. We also want to go to comp because it can pay the most for our clients. Another good reason. We also want to go to comp because it has ancillary benefits associated for a surviving spouse. So, compensation flows to the veteran. Dependency and indemnity compensation flows to the surviving family member or members who are dependents as the VA calls them. So that means an adult disabled child, minor children, or the surviving spouse. All right, compensation arises from a service-connected condition, and it's a disability. So because it's a disability, it's not just an injury. There's a disability. The veteran suffers from it today. Unlike Social Security, it's worked on an incremental basis. There's a range from 0 to 100%. 0, by the way, not necessarily a bad thing, because with a 0% rating, you still get a higher priority for your client than for VA healthcare. And we'll talk about the priorities of VA healthcare and why we want to pursue VA healthcare. The minimum amount it pays, $134 a month. Okay, pretty good deal. Look here. Maximum goes to $2,900 a month. And if we're doing special monthly compensation, $8,300 a month. Now that's a severely disabled person. They're not going to be happy at all. I've had one client that was drawing SMC. I've had 2 clients that were drawing the next increment down from it. But that's a lot of money. That can make a big difference for your clients. So let me respectfully suggest, rather than considering VA aid and attendance when you're first talking to somebody about VA benefits that pays at a maximum of $2,124 a month, maybe we want to look at these non-means tested benefits. And of course, the veteran will also be eligible for SSDI when they get this benefit. And I have many veterans that draw SSDI as well. All right, very powerful. As we said, we can't have both a comp and a non-service connected benefit flowing to the veteran. VA is going to pay the highest rate that's available to the veteran. So sometimes they may have a disability benefit, but it won't pay at the same rate as aid and attendance. So then you don't forget aid and attendance. But for service connected, never a means test. So I always go there first, if I can. Oh, it's tax-free, by the way. So take those numbers I gave you, multiply by about 1.3. That gives you a feeling then from an income perspective in terms of the overall value of the benefit. Then they'll get a rating from that. The rating can be a permanent rating or it may be a temporary rating. It'll say so in the rating decision. And it will provide the level that the disability award has been made for. The service-connected aspect of the rating will be protected after 10 years. After 10 years, they can never take the service connectivity of the rating, meaning, yes, that condition arose from service, away from the veteran. After 20 years, the rating itself is going to be protected. They can never reduce the rating itself. Prior to that, they can reduce the rating if the veteran's condition improves. Typically, though, it's going the other way. We've established service connection, and simply because of aging, we can say, no, the condition's gotten worse. Then they apply for an increase. Special monthly compensation, this is for those catastrophically disabled veterans. And you have here mobility issues or loss of special sensory organs that puts them into these higher categories. And it's rated through special monthly compensation rating codes K through S. I can talk with you offline about those if you want to get the details. You just need to know it exists. So, understanding the rating tables. the spectrum from 0 to 100. 0 is not a bad thing. It gets you service connection, so it gets the veteran a higher priority for VA health care. At the 10% rate, they actually start getting paid. Yeah, money matters. Money matters. At the 30% rate, they begin to pay for dependents as well. So that's important. The next important gate is the 40% rate. 40% and a combined rating of 70, so we have an individual rating of 40 and a combined rating of 70, then the veteran can leverage that and apply for VA unemployability if their condition precludes them from substantial gainful activity. With that leverage, they'll get paid at the 100% rate. 50% is another big gate because that's where they then move to priority group 1 for VA health care, the highest priority for VA health care. 60% for one condition or 70% combined with a minimum of 40, they can go after the VA unemployability and get paid at the 100% rate. Often, if your clients are hitting 60 or 70, yeah, they can get unemployability and then get paid at the 100% rate. Then we have 100, and then we can have 100 P&T, as it's called, permanent and total. So, once service connection is established, you can always seek an upgrade. You can always say the condition's gotten worse. And follow-on may lead to the benefits for a surviving spouse if the veteran's cause of death is related to the disability or if it materially contributed to cause of death. So how do we establish service connection? Arose from service. Here's the standard. VA calls it equipoise, at least as likely as not. That's a 50-50 standard. That's the lowest standard I know of in American jurisprudence, honestly. Tie goes to the runner. We're going to give the benefit of the doubt to the veteran, notionally. VA doesn't always follow through with that, so I have to remind them of it. 3 ways to establish service connection. Presumptively, by law, we can establish it as a result of an injury or disease in service, and that's called direct service connection, and from direct we can get secondary. And we can also get it as a result of medical malpractice from the VA, called an 1151 claim. So first we're going to talk about the presumptive conditions. These are conditions where the law says if the veteran has the condition, we're going to presume that it's associated with service. How many veterans do we have in here right now? Okay. All right. Everybody that's got their hands up, if you come down with ALS, Lou Gehrig's disease, there is a presumption that service caused Lou Gehrig's disease. Know why? Any ideas? What's the one common factor among all veterans? There's one common factor among all veterans, regardless of age, regardless of where they served. All veterans got inoculations, a series of inoculations. And we are told by statistics that veterans are 6 times as likely to contract ALS. The only way they can figure it is because of the one common factor, inoculations. Agent Orange, this is your Vietnam veterans. Work this one heavy. There are a lot of presumptions available to the Vietnam veterans, but it requires boots on the ground. That physically means you were touching the ground in Vietnam, not flying through it, not in the water. We'll talk about brown water versus blue water Navy. There's some other facilities where they will offer the presumption, but they're difficult to prove. These are the conditions associated with Agent Orange exposure. And we go down here and we look at South Korea. They did add for those personnel that served in South Korea. I can use Agent Orange presumptions a lot, either for the veteran or for the surviving spouse on a DIC claim. But boots on the ground means just that. They were touching the ground of Vietnam, or they were associated with the riverine Navy, brown water Navy. So if you get a Navy person coming in and they said they were in Vietnam, find the name of the ship that they served on if they didn't serve on the ground. And then you can go to VA's website and there's a listing where they are offering the brown water presumption to some 297 ships. It's another tool that can be used. If they're not on the list, sorry, the presumption's not available. All right, other presumptions that are available by law. Chronic diseases, some 22 diseases as specified in the CFR for diseases that manifested within 1 year of them departing service, with the exception of MS. MS, if the symptomology of MS arises within 7 years of departing of service, it's now presumed by law to be associated with service. You're beginning to learn some things here, beginning to see some things that you hadn't thought about before, or you might want to add to your checklist when you're having your client interviews. That's the whole purpose of why we're doing this. The radiogenic diseases. These are for those veterans that served at atomic test sites as a part of workers, maybe at Hanford or at Oak Ridge. Also, for those poor POWs that were on the ground at Nagasaki and Hiroshima, there are various presumptions extended on the basis of exposure to radiation for a large number of cancers. Tropical diseases for the veterans that served in the tropics, and POWs get their own particular presumptions. So if you're talking to somebody again, you want to ask the question, not only were they a veteran, particularly if they were a POW, because they have a large number of diseases where it's presumed by law, you don't even have to prove it, then that the veteran can get the benefit. All right, here's the toughie, PTSD. I admire the social workers and the psychologists particularly, because it's easy to determine if someone has a physical impairment. We can look at it, look at x-rays, look at lab work, but looking inside the human psyche, that's the difficult part to do. So I admire the practitioners that can get in there and make adequate assessments of PTSD. This is a very difficult world to establish from a proof perspective for the VA. We have some presumptions that are available. Presumptions as a result of exposure to combat, exposure to military sexual trauma, exposure to other horrific events known as stressor events. What I'm primarily going to suggest here is these are the more difficult aspects to broach with clients, particularly if you're dealing with MST. Oftentimes the clients are embarrassed to tell you that they're the victim of military sexual trauma. And I will tell you, for the purposes of this group, I actually have more men reporting to me military sexual trauma than I do women. Go ahead, Danielle.
Do they have to have reported it in order for the presumption? Does there have to be a record somewhere that they reported it?
I'll pay you later for that question. Thank you so much. But you heard Danielle's question. Does there have to be a report on file? No, there does not. Particularly because MST, there's such an onus or a bias against it. The people are embarrassed. They don't want to report it. They feel let down, etc. Hang on. So the traditional reporting that you would get, you would hope that there would be an MP report or a criminal police report. You would hope there would have gone and there's a rape kit at the hospital, those kinds of things. Sometimes it's not there. So then we look to the family members and we get lay testimony. Is the individual different now than is reported from before the reported MST? And if a psychologist or a psychiatrist is willing to affirm that the symptomology is consistent with MST, then the regulation extends a presumption that yes, PTSD should be awarded. The question in the back?
Not necessarily a question.
Okay.
The reason why things may not be or should be on file is there are two different ways to report. You can either have a restricted report or an unrestricted report. I work at Fort Gordon with the hospital, and there's always, whether it's restricted or unrestricted, there's a sharp advocate, and that's who you want to talk to. There's a sharp advocate, whether it's restricted or unrestricted, to provide the testimony that the person has in there.
Yeah, and it can go, I'm not going to say to extremes, but I want to give you a practical example of how far we can work this. I had a woman from Brunswick who was attacked by two fellow sailors some 20 years ago. At the time she had made the claim and we're working the appeal. I tried to find the sailors because the statute of limitations had run. I was going to get affidavits from them to say, hell yeah, we did it. That didn't work. She was embarrassed. She didn't tell her chain of command. She didn't tell the shore police. She did not go to the local hospital. She confided in a neighbor about a week later across a backyard fence, but we couldn't find the neighbor. Her husband was in the Navy as well, and he was deployed at the time. He was afloat. He comes back, and something's different with her. He doesn't know what is different, but something is different to the point that they ultimately divorced. So we did seek an affidavit from him, and on the basis of his affidavit that she had changed, we were able to successfully get service connection. So it's about putting the piece parts together. We got his affidavit, and then we got psychiatric assistance to say, oh yeah, this is consistent. And with that, VA gave us service connection for her case. Great question though, Danielle. This is the newest event that's arising for service connection. It's been in the news. We don't have formal rules on it yet, but this is about Camp Lejeune. For those service members that were at Camp Lejeune from 1953 through 1987. They had a problem primarily with the dry cleaning plant, but the water's contaminated. So these are the diseases that are going to be presumed to have occurred as a result of exposure to toxic water at Camp Lejeune if the veteran had been there for at least 30 days. That's going to be the requirement of the regulation. Direct service connection. Okay, this is the typical VA disability that we normally think of. Got a current disability, something happened in service, and there's a link between the two. It's a court case called Calusa, which lays out these elements. So these are called the Calusa elements. Pretty straightforward. Something happened that arose in service, and it's documented. Yeah, you got to have proof that something happened in service. Usually it's in the service treatment records, but it may be supported by affidavits or other lay evidence. And you can use independent medical opinions to sustain the claim. So, where do you go looking for the information? You first go and get a copy of the VA file. Now, this is the regional office in Roanoke, Virginia, but it shows you a pile of the VA files that are there. Still very heavy paper aspect. In fact, they had to close this building because the weight of paper exceeded the floor loading. So then it became a hazard to the VA personnel. Get a copy of the VA file. If you don't have a copy of the VA file, other documentation that may be available, service records, contemporaneous documents, police reports, newspaper clippings, and it goes on and on and on. I think the neatest way I was able to use alternative documentation, I had a veteran with a PTSD claim. We couldn't prove combat because he came back from Vietnam early prior to being awarded the combat infantry badge. So we wanted to prove combat to set up the presumption he'd been exposed to combat. He had reel-to-reel tapes where he would call home, and when he'd fill up a tape, he'd mail it. So he'd talk to his mother about 20 minutes every night. So he had the reel-to-reel tapes dropped down to CD, and I spent about 8 hours listening to his notes where he's, talking on the reel-to-reel, sending the notes home to mom. And about 8 hours into it, we found the one we were looking for, and that was when the mortar attack hit his bunk. So on the basis of that, we were able to corroborate through alternative documentation that in fact he had been exposed to combat. Okay, so the elements of a direct or secondary claim, you've got to have the current disability. It's chronic, it's not acute. This is long-term and it's ongoing. Then we have medical or lay evidence of the occurrence or aggravation. Aggravation does count. We can aggravate a condition and get VA disability for it, but it must have been as a part of the service member being in line of duty. So they can hurt themselves skiing, and that's fine. That's called line of duty. Even though they're out on a vacation time, they can still have had the injury that they'll get credit for. But if they're not in line of duty, meaning through their own misbehavior, DUIs, criminal activity, etc., they're going to be denied the benefit. Then finally, you're going to need medical evidence of a link between the event that occurred in service and the current disability. This is known as the nexus statement. And this is where I will work a lot with physicians to get these supporting independent medical opinions in terms of, yes, in my medical view, that condition is at least as likely as not related to the car wreck that this individual had in 1972. And I can say so because, and they can talk about the varying densities in the x-ray as to calcification, or they can talk about restricted motion, things like that. That's how we get there. So, direct service claims and the presumptions. Everybody that comes on to active duty is presumed to be sound. So meaning at their entrance physical, if it's not annotated on the entrance physical, and something arises in service, or even if they brought it into service, they're going to be eligible for a VA disability claim. Service connection can also happen by aggravation. They had a pre-existing event, but another legal presumption is out there that says if the condition is aggravated while they're in service, it is presumed by law that it's due to the service itself. Secondary service connection, not understood as well, but I'm going to make it easy for you. You have a disability that is simply the result of another disability. I have a direct service-connected claim. I make the claim with the VA, and the claim is for a bad ankle due to a parachute jump, bad jump. I get direct service connection then for the ankle. Because the ankle is bad, I then have had to have adjusted my gait unduly. And by adjusting my gait unduly, I put excess pressure on the knee. The knee then results in a disability. The knee's not due to the parachute jump. The knee is secondary to the jump. It's because of the ankle. But then I get service connection for the knee as well on a secondary basis. Danielle.
Just thinking like a lawyer.
Yeah.
So World War II vets come back, nobody's recognizing
PTSD.
at
Yeah.
the time.
Perfect.
But he medicates it himself, it becomes an alcoholic, has cirrhosis, or gets alcohol-related dementia later in life. Instead of going after aid and attendance, I'm going to go after service.
Absolutely. Absolutely. One of the clients that I had, he was a great older gentleman. We got him up to the 90% rate on a service-connected basis. He was a Navy Lieutenant JG, and his job was leading the assault craft in on D-Day at Normandy. Made it in the first wave okay, made it in the second wave okay. Third time coming in, he gets shot in the head. Drops to the deck, and then a 20-millimeter shell goes off next to his shoulder. He's evacuated to England. He spends the next 3 years in the hospital. Direct service connection basis, get him up to 90%. He was at 60 before they came to see me with the family. We got him to 90. I'm just talking one day to the family. They're nice people. And the daughter made a telling comment to me. She said, "Drew, we can't let Dad watch war movies anymore. He gets upset." I'm like, So we sent him off to a pretty well-known PTSD psychologist in Marietta, and they made it a determination that this gentleman was suffering from PTSD. Now, the diagnosis is made in 2012. He'd had the PTSD since 1944. It had been masked because of the totality of his physical injuries, and because when he came back, he got very focused on taking care of his family, becoming educated, working through life. It's only later in life, when those support pillars fell away, that he had more time to ruminate, then that the PTSD became evident. But I often look back to the World War II and the Korea veterans, particularly for PTSD claims. Great question. Okay, go ahead.
On the other side of that, there's still a 6-month minimum to give service to be eligible for benefits. Because where I'm working right now, we have people that have been in basic training for literally 2 days,
Yeah.
They come to argument and they want to claim that they have PTSD or something like that.
Yeah, unless there are a couple of time frames in terms of eligibility. For our older veterans, 90 days was the old minimum, unless they were discharged as a result of a medical condition that arose while they were on active duty. So say they're on a truck wreck in day 45 and, breaks their hips, breaks their legs, discharged from service. Service connection is still granted then. 1981, it changes. People have to be on active duty for at least 2 years to be receiving the panoply of VA benefits, unless they're discharged early because of a condition that is line of duty. But less than 90 days, that's going to be administrative, and that's going to be really, really hard to make the determination that that can be related to service rather than a pre-existing condition. All right, the final way you can get to service connection, proximate cause. This is VA med-mal. So instead of Federal Tort Claims Act being brought against the VA for medical malpractice, I often encourage an 1151 claim. That's because this arises from Section 1151 of Title 38, and in which VA medical malpractice is treated as the stressor event which caused a disability. And I go this route with the veterans typically because they make more money off of it. They get a monthly stipend rather than an FTCA claim, because if they do an FTCA claim, yeah, they're going to get lump sum. And then, of course, their med-mal attorneys could get 30 to 40% of that. And then if they have any other VA benefits, those VA benefits will be withheld until it works off the total award that had been given to them for med-mal purposes. So only for wrongful death would I look for a med-mal FTCA claim. Typically, I'll use 1151 as the way to go. All right, so the ratings themselves, they are what they are. It's governed by Chapter 4, Title 38. Some of them make no sense, and I'll tell you that. And they haven't really revised the rating table since 1946. So, for example, tinnitus, ringing of the ears. I don't care how bad a veteran's tinnitus is. If they have service-connected tinnitus, they're going to get a 10% rating, period, end of statement. Doesn't matter how loud, doesn't matter how soft. 10% rating because that's what the rating table says. The feet, if they have a foot problem, the best they're going to do is 50%. Because that's what's provided for by statute. So you have to know the rating tables a little bit when you're talking to the veterans or the families to work it through. There is a bilateral factor. If we have a foot problem or a knee problem, but it's for both knees, both feet, then we can apply a bilateral factor and increase the overall rating disability because both limbs are involved. We don't pyramid. Pyramid is the concept where we take different symptomologies associated with the same disability and try to add it all together. So because I have a knee issue and my flexion is limited to 10 degrees, that's entitled me to one VA rating. But the extension of the knee entitles me to a different rating. Well, VA will only provide for the highest of the ratings, and that follows 38 CFR 4.16. You get a single rating if you've got a single disability, or you may get a combined rating for multiple disabilities. A combined VA disability rating is not the summation of their individual ratings. And we'll walk through this like this. I'm going to put a notional veteran in front of you. Well, yes, this notional veteran is in fact in front of you, standing in front of you right now. The notional veteran has a 30% rating for one condition, 10 for another, 10 for another, 10 for another, and 0 for the other. What do you think his combined rating is? It's on the slide. It's not 60, it's 50. Because they take the highest disability rating first, and then they say, okay, after we apply the highest disability rating to the veteran, he has a residual functional capacity of 70%. That 70% then becomes the baseline for applying the 10% rating. So 30% off of 100, then we do 10% off of 70. That's 7% additive to the 30. Then we do another 10% off of 63. You see how this works? Only VA could come up with a system like this. So a lot of times you'll have people coming in saying, well, I'm entitled to this, but they're only paying me for this. You need to understand how the combined rating tables work. Alternative paths to getting that highest rating, that's what I was talking about with individual unemployability. VA's version of SSDI, service-connected condition, and the service-connected condition precludes the veteran from substantive gainful activity. Okay, the ratings themselves. You can appeal the rating, the amount of the rating, or you can appeal the fact that service connection was not provided for the rating. Both of them are good grounds for filing an appeal. So comp flows to the veteran. Now let's look at DIC. DIC flows to the eligible family member. $1,254 a month, plus VA health care for the rest of their life. Due to the fact that the veteran's death was due to a service-connected condition, or that service-connected condition materially contributed to cause of death, or veteran had been rated at least 100% for the last 10 years. I had one appeal that I did. The veteran was rated at 100% for 8 years and 11 months. And he's rated for depression, and he shoots himself. Suicide. VA denied it on the basis of 10 years. So then we had to go back and establish suicide as cause of death due to depression. Really aggravated me. But that's some of the good work that's out there that can be done. And you can help your clients when you have these discussions with them. Okay, here we go. What do I need to say about VA pension to this crowd? Not a lot. You all know the pension rules. You know how pension works. Means tested benefit. It's a tiered benefit, 3 different levels depending upon medical need. And of course, we have asset and income test. And some CLEs spend hours on end simply talking about how to appropriately do transfers so we can make people eligible from an asset perspective. Here are the basic rules for pension. I think we all know those basic rules. At least 1 day of wartime service. Doesn't mean they had to have served in a wartime area. They just have at least 1 day of wartime service. And then the medical need that arises. This is the rates for the single veteran. For a veteran with spouse, it's $21.24 or $21.54, I believe. I can't remember, Danielle. Okay. Now, asset transfers. This is hot off the press. I just checked the Federal Register again this morning. VA issued a proposed rule to initiate a look back on transfers. With that, they received some 867 comments. So following notice and comment under the APA, VA has to respond to these if they're not duplicative in nature. They're still working with that. So they have yet to publish the final rule. Under the APA, we will see the final rule get published in the Federal Register, and that'll provide for a minimum of at least 30 days before it's implemented. So you know that it's out there, and that's about the look-back period, implementing the look-back period. Tangential considerations, this stuff takes a long time. It does. Sometimes people die in the midst of a VA application or a VA appeal. That's when we put a survivor in place through something called substitution. You need to know what substitution procedures look like. About 30% of the time these days, I have to implement substitution on behalf of my clients because of this going on. Then we have the VA fiduciary program. This is a little different than state-run guardianship, state-run conservatorship, run by the VA through its fiduciary hubs, 6 of them. VA fiduciary determinations are appealable, and you should appeal them if possible. Sometimes we appeal them on the basis of the veteran's at 100% rate, but he thinks he's capable of still managing his money, and he wants to appeal the determination. He wants to manage his own money. Okay, fine. Good reason to appeal it. Sometimes we have tangential considerations because a federal incompetency determination by the VA is reported to all federal agencies. And we get these gentlemen and ladies sometimes that think this impinges upon their Second Amendment rights, and they object to a firearms determination. Again, that's a reason to appeal it. I do those rarely, but it'll exist, and you can appeal it. You can appeal it just like any other VA decision that's out there. Now let's talk about VA healthcare, just a little bit. In Georgia, 3 VA hospitals. Georgia, though, is served by 6 VA hospitals because of the regional approach of how VA does business. For example, Tuskegee VA Medical Center in Alabama covers down in Columbus, Georgia. When you're down in South Georgia, they're getting VA hospital support from the VA hospital in Gainesville or maybe in Jacksonville. And when you're in East Georgia, it may not be coming from Augusta, but it may be coming from the VA hospital in Charleston. So you have to kind of know what clinic is supporting your veteran, because the clinic in turn works for that hospital. So we've got the 3 main hospitals, then they in turn do regional outpatient clinics known as CBOCs. And they've got a geographic footprint throughout the state. Oh, in fact, yeah, because up in North Georgia, David, above you, then they're getting that support out of Chattanooga. Yeah. What can they do? The panoply of VA medical support. Pretty broad. VA is the largest healthcare provider in the United States. Did you know that? Larger than Medicare. VA healthcare is typically pretty good, and I try to go there because it's usually fairly inexpensive for the veteran, but they can always get care or get a referral out to where they are. You got to deal with the bureaucracy, but that's okay. But look at what all they can do to include nursing home care. How many VA nursing homes are there in the state of Georgia? Who knows? 3. So if you've got clients in need of skilled nursing care, and maybe they're eligible for a VA nursing home, it's in their best interest for you to pursue that. So you need to know what the eligibility requirements are for VA nursing home. Similarly, in-home care, respite care, palliative care, you need to understand how the level of VA disability or VA pension impacts the appropriateness of getting this associated care from a health perspective, because we know how much skilled nursing care costs. So, priorities for VA health care. 1 through 8, 1 is the highest priority. That is for those veterans who have a 50% or higher service-connected disability, period. Boom. Who can argue with that? You know, I think that's probably the right way to set it up. Priority 2, veterans at the 30 to 40% rate for service-connected. Priority group 3, POWs, Purple Heart, or people that have been medically discharged. Pretty good ways to establish very quickly a very high level of VA health care. So let's talk, for example, about VA nursing home. What does it take to get into a VA nursing home, and what does it cost? What does it take to get into the VA nursing home? They need skilled nursing care, and they have a service-connected disability rating of 70% or higher, period. That's what it takes. What does it cost? 0. 0.
Are they full?
No. No. Well, it depends on the location. Because there's 3 in the state. There's 1 in Augusta, 1 in Atlanta, and 1 in Dublin. Dublin always has bed space. Always has bed space. Augusta runs hot and cold if they do or not. Atlanta may have bed space. If the veteran is entitled to a bed and bed space is lacking, VA then will pay for a contract bed. Heck of a better deal than Medicaid, wouldn't you say? Yeah, I think so. Then we look down here. This is why you go after aid and attendance. Sometimes it's not about the money. It's about getting them to priority group 4 for VA health care so they can get that medical care that they need, and so on and so on. Means testing kicks in at these bottom 2. Now, the means test is only applied at those facilities where resources are tight. So if you go to Atlanta, they're going to apply means testing. You go to Augusta, they're going to apply means testing. If you're a veteran and you walk within 50 miles of Dublin, they're going to lasso you and try to bring you in and give you free health care because they're quite literally looking for work. By the way, veterans are supposed to be associated with a treating VA medical center. Yes, I belong to the VA Medical Center at Dublin. Never have to wait, nice people, and it's Middle Georgia. They have a different approach to things. How do you get into VA healthcare? This is how you do it. VA Form 1010 EZ. Just drop that application, get in, get started. Pretty simple, pretty straightforward. Can drop it at any of the medical centers. Can also drop it at that local VA clinic, the CBOC, community-based outpatient clinic. Then the National Cemetery System. We've got one of the newest ones right here in Georgia, over in Canton, Cherokee. This is what VA does for the veteran or the veteran's family in terms of the benefits for interment. Note, this does not include Arlington. Arlington is special. Arlington is still run by Department of the Army, and they're going to keep it for a while. They don't have any plans on giving it up. Then we have the Georgia Department of Veterans Service. Let's distinguish that from the VA. And you need to know these people exist, and they're very good at what they do. Mike Roby is the commissioner, followed Commissioner Pete Wheeler, who's the longest serving commissioner for Veterans Service of any state in the nation. Pete assumed his duties in 1964. He passed away last year. I was at a meeting with Pete one day, and he showed me his bar card. He was really proud of it. And he entered the bar in 1949. I was like, man. But he did a great job for the state of Georgia building the Georgia Department of Veterans Service. They have a county presence. Every county has an office assigned to that county. For the rural counties, they may be covering down to 3 or 4 counties, but they can be a great way for your clients to have input into the VA directly on an initial basis. What do? Well, one of the things they do is they run the state war veterans homes, Milledgeville and Augusta, skilled nursing facilities for veterans of wartime period in the state of Georgia who had an honorable discharge and have lived in Georgia for at least the last 5 years. Who knew there were state of Georgia skilled nursing homes for veterans until today? Danielle knew it. But there are 2 of them, Milledgeville and Augusta. You're going to leave here now knowing there are 5 veterans nursing homes in the state that you may not have known before. Qualifications to get into Milledgeville or Augusta: good discharge, served during a wartime period, and have been a resident of the state of Georgia for the last 5 years. That's it. What does it cost? $24.98 a day. Skilled nursing care. Skilled nursing care. 104 beds in Augusta, 454 beds in the Milledgeville facility. Augusta, they may have to wait for a month to 2 to 3 months because it's a popular facility to be in because it's adjacent to the VA hospital. And it gets confusing. It's also adjacent to the VA Veterans Home. Milledgeville,
The difference is they're managed, the state homes and the VA homes are managed by different.
Right. Yeah, Milledgeville and Augusta, the state war veterans homes, managed through DVS. The 3 VA skilled nursing facilities, known as community living centers, managed by Veterans Health Administration. Also, we've got state cemeteries for our veterans that are out there, and then other ancillary benefits that you need to know of, such as free driver's licenses, reduced licensing fees, things of that nature. So with that, that's the conclusion of my formal presentation, subject to your questions.
Any questions?
You probably said this and I just missed it. So for a veteran who served during wartime, you can get health benefits even if you don't have a service-connected issue?
Correct. And it's going to be means tested based upon the ability of the VA facility to administer those benefits. So if it's somebody in Metro Atlanta, they're going to have a higher priority than someone who didn't have wartime service, but means testing still comes in. So it's going to be they're going to be in the lower priority groups, so they're going to really have to work it out on a case-by-case basis with the people that control enrollment at the hospital. And I've been talking with them about this, in fact. They've got some particular rules. There's about 20 different exceptions where they can even make them up higher. We know of the POW exception, but there's another exception for veterans that had exposure to Agent Orange. They automatically get bumped up a little higher. The veterans that do the radiogenic tests, they can get a little higher priority. So they just need to go in there and aggressively ask. That's the bottom line with it. Sabrina, what are you going to do to me? Little rascal.
So because Dublin has space,
Yes.
do they ever accept veterans that are lower than 70% or maybe some non-service connected?
Good question. There is an ancillary facility to the VA that does not rise to the skilled nursing care level. It's called domiciliaries. The purpose of the domiciliaries is supposed to be short-term housing to help the homeless veterans reintegrate. And objectively, the domiciliaries are designed to provide a place to stay for up to 180 days. For example, Fort Mac just built a new domiciliary bed wing, and they got 40 beds there. That the purpose is get the veteran in, get them clean, get them a safe place to stay, get social workers engaged with them for reentry into society. And if they show appropriate improvement, keep them there for 180 days, and then they can find them a place to stay. I had one family who had a veteran that used the domiciliary system in Augusta, and because no one else was using the facility, he had been there for 12 years. And then they were seeking to discharge him, but they did offer him a deal. We'll either discharge you or we'll let you use the domiciliary in Dublin, which had 2 or 3 beds occupied. And he was objecting to it on the grounds that, no, you let me stay here for 12 years. So the family got me involved. And I said, no. We got to follow the rules here, folks. But there is a domiciliary system that's out there primarily designed for the homeless vets. And it's a pretty good system. I like the way they do that. Other questions? In the back.
Thanks for the valuable information, Drew. Question about how you charge for the service-connected disability clients.
Thank you. Yeah, 2 ways of getting paid. Getting paid's important. Ruth Ann and I were having that discussion, and she was asking me about that. And my P&L, I typically run, I'm going to say about 60% of my P&L is borne by being an elder law attorney. But about 75 to 80% of the time, I'm doing the VA stuff. So it's a balance, and getting paid is important. 2 ways of getting paid in the service-connected world. 1, I charge an hourly rate for consults, for general consults about VA benefits. And it's not just limited to service connection, but also to pension, the healthcare aspect, things like that. I can do that. When someone evokes an interest or a desire to specifically file a VA claim, I must stop. I can't get paid from that point going forward. There's an opinion out from General Counsel of the VA. At that point, I just turn them over to Georgia Department of Veterans Service or the local VA and say, go make your claim. I won't help them build the claim. I won't do anything else because I can't get paid. General consults, advising, I can get paid there. The other way I get paid is I get paid on a contingency basis with VA appeals. And there it's a straight 20% rate should we prevail on appeal. So what that means is I have to get really good at picking the right client and the right appeal, or knowing I can develop it with sufficient weight of evidence such that then I can prevail. Good question. Any others? All right, with that, I thank you very much.